Hello, everyone. Good morning, good afternoon, and good evening. Thanks for attending this webinar. I'm Bing Chen, partner of SPTL, in charge of patent matters in telecommunication and computer science. As one of the leading IP firms in China, we provide full range of services for IP matters, both domestically and abroad. Today, one of our senior attorneys, Ms. Li Yang, will talk about a very hot topic, focusing on patentability of AI-related inventions in China. Ms. Yang has joined SPTL for more than 10 years. She has a wealth of experience in the field of telecommunication and computer science. Her practice involves patent prosecution, validity determination, patent infringement litigation, and patent search and analysis. Her presentation will last about 30 minutes with up to 15 additional minutes for questions. Should time not allow for every question, you are all welcome to send us your questions by email and we shall duly reply. Also, you may raise your questions through text message during the presentation. Now, let's welcome Ms. Li Yang.
Thank you, Bing. Hi, everyone. Greetings from Shanghai, China, and good morning to those in Europe and good afternoon to those in the North America. Thank you very much for taking your time to attend this webinar under the global pandemic situation. And I hope everyone's doing well and stay safe and sound with your families. And today, I'm going to talk about AI-related application patenting in China. And in recent years, there have been rapid technology advances in the area of computer-implemented inventions, and which have resulted in significant increases in the CII-related patent applications. And the most popular topic in this regard is the artificial intelligence. And this represents a challenge to patent offices and applicants alike, as does the increasing penetration of AI technologies into other areas of innovation. A further challenge for the applicant is the fact that different patent offices operate under different legal codes, and therefore they may apply different approaches to the examination of such patent applications. We will try to go with today's topic in these 4 parts. First, let's face the challenges that the AI patent applications will face. The first challenge is the patent eligibility. First, let's get back to AI. So the question is, what is artificial intelligence? And we may use some words to describe it. It is usually invisible, and it does not possess a physical entity outlook. And most of the time, it is embodied as a method or a sequence of actions imitating human intelligence, but is implemented by machines or computers. But wisdom or intelligence is something that is abstract in nature. And as we all know, that any idea or concept cannot be protected by patents, because nobody can preempt or monopolize or control other people's minds in such a civilized societies nowadays. So patent eligibility is to distinguish what are people's thoughts and what is a technical solution that is eligible for patent protection. Let's look at the generation parts of knowledge. It is usually like this, as the arrow shows. At the very beginning, there is knowledge and source generated in human's mind, like the fundamental mathematical or physical principles like the Newton's laws, the theory of relativity from Einstein. And the second stage is that these knowledge and source are implemented by human beings, like using a pen and paper, trying to solve a physical problem or a mathematical equation. And after that, a machine or a computer might be utilized to solve such a problem or equation for us. And finally, the process of the calculation of these problems and equations might be utilized to solve a practical problem that is happening in a specific industry in our daily lives. So with the development of the knowledge, we can see that there is no explicit line between intelligent ideas or abstract ideas and technical solutions. So when we talk about patent eligibility, what we actually do is to trying to set a threshold in this generation part. Inventions or creations beyond this threshold are technical solutions that are eligible for patent protection, while the opposite side represents abstract ideas or mental activities that are discretionary for everyone. It has to be noted that such a threshold might be changing dynamically with the progress of technology. So the boundary of technology is not clear, and the scope of what is eligible for patent protection may be expanding with the development and advancement of science and technology. So maybe that's the reason why we do not have a specific definition of what is technical prescribed in laws or regulations. The second challenge that AI patent applications face is that when evaluating their patentability, like the novelty and the unobviousness, it might be the case that not all of the contents in the claims will be considered by the examiner when evaluating the inventive step of the claimed invention. And we shall talk about this later. Now let's look at the laws and regulation part. The PRC law has its provisions related to patent eligibility and patentability. In specific, Article 25.1 of the Chinese patent law lists the subject matters excluded from patent protection, including rules and methods for mental activities, which might be the reason of rejection for AI-related applications. And Article 2.2 provides a positive definition of a patentable invention. An invention refers to any new technical solution concerning a product, a process, or improvement thereof, while Article 22 relates to the patentability examination. Further explanations and rules are provided in the guidelines for patent examination. In Section 4.2 of Chapter 1, Part 2, it explains what mental activities refer to, and specifically provides typical examples that fall within rules and methods for mental activities. For example, methods of managing commercial activities or economy, mathematical theories, and methods of conversion or calculation, methods of presenting information and the like. The claimed invention will be rejected under Article 25.1 if it merely relates to the pure methods of doing business or doing mathematical calculation. But what if we implement all these methods in a technical way? The answer will be different. So now let's move to Section 2, Chapter 1, Part 2 of the guidelines. It further clarifies what is a technical solution. A technical solution is an aggregation of technical means applying the laws of nature to solve a technical problem. A solution that does not adopt technical means to solve a technical problem and thereby does not achieve any technical effect, complying with the laws of nature, does not constitute a subject matter as defined in the Chinese patent law. So in other words, a technical solution is composed of a technical problem plus technical means and technical effect with logical relationship thereamong. And in this regard, technical problem, technical means, and technical effect are usually called the three technical elements in Chinese patent practice. These three technical elements are the criteria for determining whether the claimed invention constitutes a technical solution. So only when the claimed invention possesses all these three technical elements simultaneously, it will be considered as a technical solution under the Chinese patent practice. to accommodate the increasing number of AI-related applications and to respond to the technology innovations in new industries and fields like AI, blockchain, big data. CNIPA has made frequent revisions to its guidelines in recent years. For example, in the revisions in 2017, regulations on business model related inventions were added. And since then, computer readable medium claim and a mixed type claim are allowed. A mixed type claim refers to, for example, a device or a system which comprises a processor being configured to execute instructions stored in a memory. This type of claim is called a mixed type claim. And in the latest revision in 2020, CNIPA has updated its examination guidelines to include a specific section on how the office is likely to assess patent applications regarding new industries and fields like in artificial intelligence. Specifically, a new Section 6 was added to Chapter 9 of Part 2 of the guidelines. The update to the guidelines further clarifies that the examination criteria of applications related to AI, Internet Plus, big data, and blockchain. The new Chapter 6 states that if a claim includes technical features and non-technical features like algorithm features or business rules, the claim as a whole would not be simply determined as a rule and method for mental activity just because it contains these non-technical features. It should not be excluded from patent protection. So if the claim as a whole is not considered as rules and methods for mental activities, then it is necessary for the examiner to further determine whether it belongs to a technical solution under Article 22.2. The new Section 6.1.2 further clarifies that a claimed invention constitutes a technical solution as long as it satisfies the 3 technical elements requirement, even if the claim includes algorithm features or business rules, which means a claim containing algorithm or business rules will not be certainly excluded from patent protection. And further, the new Section 6.1.3 relates to the inventive step evaluation of a claimed invention. It clarifies that even non-technical features shall be considered by the examiner when evaluating the inventive step of the invention if these non-technical features functionally support and interact with the technical features in the claim. As an example, specific and physical meanings of the input and output of an algorithm might be helpful to demonstrate the interaction between non-technical features and technical features. And other examples might include the specific application of an algorithm to a specific application scenario or a field of use, or the algorithm is closely integrated with the internal components of the computer. We may look into this in detail in the sample case section. So actually, the new Section 6 provides a clear picture of the procedure for examination to be followed by the Chinese examiners. And altogether, there are 3 steps. First, it shall be determined whether a claimed solution comprises any technical feature. If there is at least one technical feature, for example, a computer or a processor, then we should proceed to step 2, where it is determined whether the claimed solution is a technical solution. As we mentioned above, it should be determined from the 3 technical elements respectively. That is, whether the claim adopts any technical means to solve a technical problem and achieve a corresponding technical effect. If not, the claim solution is not a technical solution. Well, if yes, that means that we have passed the eligibility examination, and now we shall proceed to step 3 to evaluate the patentability, for example, the novelty and the inventive step of the claimed invention. And for step 3, an illustration is presented here. First, we have a scope of our invention, like the circle, and then we have a scope of the prior art. And the upper portion represents the distinguishing features of our invention in view of the prior art. In AI-related applications, mathematical calculations, business rules, or algorithm features are commonly recited in the claim. So the next step for the examiner is to divide the upper portion of the distinguishing features into 2 categories, technical features and non-technical features. And after that, the non-technical features part shall be further subdivided into 2 parts, one of which functionally support and interact with the technical features in the claim, while the other does not. So when evaluating the inventive step, only this portion will be considered by the examiner. This is quite similar to the problem-solve approach practiced by EPO when evaluating the unobviousness of a claimed invention, wherein only features that provide technical contributions will be considered by the EPO examination in its inventive step determination. Now let's take some sample cases for further explanation. We have 4 cases today, and the first 2 cases mainly focus on the eligibility examination. And for the third and the fourth case, we shall go through the entire examination procedure. The first case relates to a modeling method using an MRAN algorithm based on RBF neural network. This application applies the MRAN algorithm to a numerical control low-speed wire cutting machine tool to improve the efficiency of implementations, because the RBF neural network is better than the commonly used BP network in terms of approximation ability, classification ability, and learning speed due to the reduced amount of calculation. And the accuracy of modeling is also increased. The claim as drafted is a thermal error modeling method. This is a real case. The claim 1 is characterized in a network structure and the steps of the algorithm. So now let's start with the eligibility examination. We altogether have 2 steps. In step 1, we shall determine whether there is any technical feature in this claim. It can be seen that a wire cutting machine tool is recited. It is a technical feature. So the answer to step 1 is yes, we have the technical feature. So we now proceed to step 2, whether it constitutes a technical solution. As we mentioned, this application tries to solve a technical problem and achieves corresponding technical effect is what we try to determine. And the current claim 1, it merely recites using this RBF neural network MRAN algorithm for the thermal error measurement of the tool in its programmable. But except for the programmable portion, each step of the calculation and the parameters have no relationship with the thermal error of the wire cutting machine tool, and no specific physical parameters of the specific technical field are defined. So the method as drafted as claim 1, it does not specifically describe how to apply this algorithm to the thermal error measurement of the tool in the modeling process. So it neither adopts a technical means nor solves a specific technical problem of building a thermal error model for the wire cutting machine tool. So this means that the pending claim 1 does not possess the 3 technical elements So it does not constitute a technical solution. The conclusion is that the claimed solution merely relates to an abstract algorithm rather than an application of this algorithm. We may see from this case that generally describing using an algorithm for a field of use in the preamble is not sufficient. Such a limitation in the preamble of the claim is no more than generally linking the use of the algorithm to a particular technological environment or field of use. Such a loose coupling between the algorithm and the application scenario would not be enough to prove that the solution is an application of the algorithm. And this is quite similar to the prong 2 determination of step 2A of the revised Alice-Mayo two-step test for patent eligibility by the USPTO. And now let's take a look at the second case. The second case is about a training method for deep neural network model, particularly focusing on the problem related to the size of the training data. The solution primarily relates to selecting one of a single processor scheme or a multiple processor scheme based on the size of the training data so that faster training speed may be achieved. We shall also use the two-step method for eligibility examination. The claim is drafted like this, and this is also a real case. Step 1, it's about, is there any technical feature in the pending claim 1? We can see that there is at least a processor literally recited in claim 1. So the answer to step 1 is yes. And step 2, whether it is a technical solution. The 3 technical elements are respectively assessed. Different training schemes are directly related to the time and efficiency of the processing of training data by computer systems. So in our current application, to solve the problem of low training efficiency of fixed processor scheme, different processor training scheme for training data of different sizes are selected. This follows the law of mapping between the processing performance of the computer hardware and the training data size. And an effect of improving the training speed is obtained. So the improvement of the internal performance of the computer system is based on the close integration of different data training methods with processor executed processes. So in this regard, the 3 technical elements requirement is satisfied by the pending claim 1, and therefore it is a technical solution under Chinese patent practice. And from sample case 3, we shall go through the entire examination procedure, including the eligibility part and the patentability part. The claim is present as like this. Sample case 3, it is related to a seat allocation method for a group of passengers. When multiple passengers are allocated seats as a group, a traditional way to do this is to accomplish it manually, or these passengers will be placed separately. And the present solution here calculates a satisfaction value for each seat for each of the passengers. And it also calculates a global satisfaction value for each seat. Then it uses a mapping between a geometric shape and the number of the passengers, and identifies several groups of available seats corresponding to the selected geometric shape. And finally, it will select one group of available seats according to the individual and the global satisfaction values calculated above. So altogether, we have 3 steps. Now, first step, is there any technical feature existing? The answer is yes, because it includes technical features like a memory processor. So it is not a pure rule and method for mental activity. And step 2, technical solution determination. As introduced, the problem to be solved here is how to put a group of passengers together automatically by computers. It can be seen that selecting and identifying a geometric shape corresponding to the number of passengers are recited in the claim, and multiple groups of available seats are identified accordingly. And these steps or means are technical means complying with natural laws. And the present claim 1 is able to achieve an effect of automatic seat allocation by using such means. And this effect is a technical effect. So the answer is that it satisfies the 3 technical elements requirement, and it would be considered as a technical solution. And parsing the eligibility part, we now move to the patentability part. First, let's look at step 3, part 1, novelty assessment. The subject matter of claim 1 is not anticipated by the prior art document 1 we searched. It differs from D1 in its specific seat allocation rule. And this means that claim 1 parses the novelty examination. And now we proceed to the step 3, part 2, determining whether the distinguishing features of claim 1, including any technical features and non-technical features that functionally support and interact with the technical features. We shall determine whether these features are unobvious to those skilled in the art. Well, in our case here, the distinguishing features lie in the specific seat allocation rule, which is selecting one group of available seats from the multiple group of available seats according to the calculated individual and global satisfaction values. Such a rule is merely a rule for determining seat allocation according to commercial purposes. The satisfaction value is calculated according to business rules. So the problem to be solved, determined based on the distinguishing features here, is not considered as a technical problem because such a rule does not make any technical contribution. So when evaluating the inventor step of the pending claim 1, the distinguishing features of claim 1 here would not be considered by the examiner. And the conclusion is that the claim 1 does not involve an inventive step in view of the searched cited document D1. And let's see the last simple case. It is related to a method of facilitating shopping on a mobile device. First, the user selects one or more products to purchase on his or her mobile phone, and then his mobile phone will transmit the product data and the location of the mobile phone to a server, and the server uses these information to retrieve an optimal shopping tour from a cache memory where optical shopping tours of previous requests are stored. And then the server will transmit the optical shopping tour back to the user. This is like the solution of the sample case 4. And we also use the 3 steps to determine, first, is there any technical feature? And we can see that there are at least a mobile device, a database, a server in the pending claim. So the answer to step 1 is yes. And we move to step 2. Is it a technical solution? The problem to be solved is to facilitate shopping on a mobile device. It is not a pure shopping method in the commercial society. So it is a technical problem. And the means adopted here are that the user selects products on the mobile device, and it transmits the selected products data and the device location to a server, and then the server accesses a database of vendors and a cache memory of the optimal shopping tours. So in order to solve the problem of providing the optimal shopping tour on the mobile device, means of determining an optimal shopping tour based on the device location are adopted. It further describes the interaction between the mobile device, the server, and the database, and the cache memory. So these are considered by the examiner as technical means. So correspondingly, a technical effect is achieved. So the pending claim 1 as drafted here is considered as a technical solution and is eligible for patent protection. And we move to the patentability part. Step 3, part 1, about novelty. The pending claim has the following 3 distinguishing features in view of a search the document 1. First, the user can select 2 or more products to purchase rather than a single product. And the second one is that an optimal shopping tour for purchasing these 2 or more products is provided to the user. And the difference number 3 lies in the optimal shopping tour is determined by the server by accessing the cache memory, where the optimal shopping tours determined for previous requests are stored. Now, we concluded that claim 1 possess novelty, and we shall move to step 3, part 2, to determine whether it involves an inventive step to determine whether the distinguishing features demonstrate unobviousness to those skilled in the art. First, we shall divide the distinguishing features into 2 categories, technical features and non-technical features. And in our case here, difference 1 and difference 2, they are non-technical features, while difference 3 is a technical feature. Difference 1 and 2, they represent modifications of the underlying business concept because they define producing an ordered list of shops to visit will sell these products. And no technical purpose is served and no technical effect can be identified from these differences. So this means that these features do not functionally support and interact with the technical features, such as the mobile device, the server, the database, or the cache memory in pending claim 1. And they do not functionally support and interact with the distinguishing technical feature 3. So when evaluating the inventive step of the pending claim, difference 1 and difference 2 will not be considered by the examiner. Only difference number 3 will be considered, and the inventive step determination would be only based on the difference 3, which is further dependent on other prior arts. At the last part, I would like to provide you with some takeaways for AI-related patent in China. And according to statistics from IP House and Wenshunet as of February 2018, the guidelines for patent examination consulted by the court in administrative lawsuits has a 32% of all IP administrative lawsuits. So the guidelines for patent examination as a departmental rule, although it is at the bottom of the Chinese legal hierarchy, it is also an official source of law in China, according to the legislation law. And although the court does not have to abide by the guidelines, but the court may consult and reference to the guidelines in IP lawsuits whenever they think it is appropriate and necessary. So with the frequent revisions and updates to the guidelines, trends and attitudes of the CNIPA toward new industry inventions may be reflected. So the first takeaway for you to pay attention is to pay attention to the revision of the guidelines. It is highly possible that the guidelines will be further amended, and in a draft of revision proposed early this year for public review, one point, among other things that should be noted, is that computer program product may be a statutory subject matter. And in this regard, it might be a choice for the applicant to have a set of computer program product claims described in the specification when they file patent applications now to be prepared for any further potential opportunity to incorporate those features or those claims into the claims in the future. And secondly, for eligibility part, adding technical elements into the claims would help to eliminate the possibility of relating to pure rules and methods for mental activities. And for AI implementations, improvements to algorithms should be closely related to the internal components of a computer. And for AI applications, describing how to specifically apply the algorithms to a practical field of use is of the most importance. Also, in the draft of revision to the guidelines for public review, another thing we should pay attention to is that among the three technical elements, the technical means will be possibly superior to technical problem and technical effect. And this means that it might be the case that a claimed invention will be considered as a technical solution as long as it adopts technical means. And AI-related applications are usually implemented by computers. So this means that being computer implemented, as we have already adopted technical means. So being computer implemented necessarily solves a technical problem and results in a technical effect. So the future examination on AI-related applications will be possibly be more focusing on the patentability part, not on the eligibility part, just like the EPO's current practice. And the third takeaway for patentability examination, as discussed in our sample cases 3 and 4, you should always describe how the non-technical features support and interact with the technical features. This might help with the unobviousness test. For example, you should define the specific physical meanings of the input and output of your algorithm. And you do not finish or conclude a method with a digital value calculated from the algorithm, but you should always relate this digital value result to a specific physical meaning or parameter that exists in your applicable scenario. And always emphasize the specific suitability of the algorithm to the specific field of use or application scenario, and demonstrate the causality between the performance improvement brought about by the algorithm and the non-technical features. And this is the end of what I want to discuss today. And thank you all for your patience, and you're most welcome to contact SPTL via emails or phones if you have any questions or queries. Contact information may be found on the slide. Thank you so much.
Thanks for your sharing, Ms. Yang, which is quite informative. Now we will go to the Q&A session, and you may raise your questions through the text input. Okay, we got a message from Mr. Ryan Peterson. The question is about, are there any tips you can share for drafting the description for AI-related cases?
Okay, thank you for your questions. When I talk in the presentation here, mostly I will focus on the claim part, how to draft the claim and what we should pay attention to. And the description is also an important part that we should pay attention to. Firstly, we should describe multiple embodiments that are supportive of the implementation of the solution of your claims. And specifically, if your solution is like an algorithm applied to a specific field of use or an application scenario, and you should specifically describe the context and the application context of how to apply such an algorithm, especially the special suitability, like how the parameters in your algorithm are defined in the real world, in the real application scenario. This is about the embodiments description for supportive of the claim. And secondly, the performance improvement, like the quality, the efficiency, or the precision that you improved by utilizing an algorithm. And you should specifically describe how to do that, how you achieve that result in your description. And thirdly, I think the causality between the performance improvement and the algorithm you utilized, especially the non-technical features, how they interact with the technical features and cooperate with each other to objectively support the improvement of your performance or the accuracy or the precision of your invention. And I think
yeah. Thank you, Ms. Yang. We got another message, another question from Mr. John Kind. His question is that in one of your examples, you said that determining a geographic shape was technical. Could you explain the reasoning on that more? It seems like something that could be a mental process.
Thank you, John Kind. And what you mentioned is, I think it's in sample case 3 of the step 2. Where we determine whether it constitutes a technical solution. And the reason why we conclude that it is a technical solution because we think it adopts technical means. And the technical means is specifically embodied or exemplaried here as the selecting and identifying geometric shape. And these selecting or identifying, they are not doing by discretionary to everybody. It is implemented or accomplished according to the number of the passengers. So like if the number of the passengers is 3, and we might select and identify a triangle. And if the number of the passengers is more than 3, we might identify a geometric shape corresponding to the number of the passengers, because the number of the passengers, they do not change with people's mind. So this step, what we do is to identify a geometric shape according to the number of the passengers, which is not changing according to people's mind. So such a means or measure is considered as a technical means. So you said that it could be a mental process. Usually a mental process starts with a verb like determining, evaluating, and something that you can do or you can perform in human mind. But we should also, except for the verb that we should notice in the claim, we should also pay attention to how to do this or how to accomplish this determining or evaluation step, whether it is accomplished purely in people's mind according to a person's subjective opinion, or it depends on some objective rules and phenomenon, or anything like the number of passengers that do not change with how I think or how other people think in their mind. So I think that's why we identify such features as a technical means.
Okay, thank you, Ms. Yang. Any questions? All right. Thank you all. Different jurisdictions may have different criteria on examination of AI-related inventions. But we all hope that in the near future, such examination criteria will be harmonized in most jurisdictions to facilitate patent protection in this area throughout the world. As always, we SPTL will provide webinars centered on various topics in IP in order for it to bring you the most added value. Our next webinar will be provided in early July, focusing on protection for designs and the newly revised patent law in China. Please follow our post or notification. This is all for today's webinar, and thank you, and hope to see you next time. Have a good weekend.
Have a nice weekend, and bye-bye, everyone.